which is this, you refer to this as, I guess this was our case, the crazy case.
That's very astute of you.
I didn't get a sense that the other cases were in the crazy category, so.
Calling pages 11 through 47, case A 831-169, Christopher Wren versus AffinityLifestyles.com.
Go ahead and state your appearances.
Your Honor, Will Kemp, Plaintiffs.
Good morning, Your Honor. Eric Pepperman for Plaintiffs.
And good morning, Your Honor. Teddy Parker, also here for the plaintiff here.
Samuel Mertz, attention Plaintiff.
We Brandon David Spurlock for Whole Foods at United Natural Foods West.
Kelly Evans on behalf of Hanna.
Scott Pierce on behalf of Hanna.
James Kilroy on behalf of Milwaukee Instruments.
Morning, Your Honor. Kevin Rising on behalf of Costco Wholesale Corporation.
Aaron Mockenbacher, all from behalf of Costco.
Morning, Your Honor. Karen Costco, Nevada Beverage.
Fort Dodville on behalf of Nevada Beverage.
Good morning, Your Honor. Joel Odou and Eric Freeman on behalf of Real Water Inc., AffinityLifestyles.com, and I'm appearing on behalf of Real Water Gold Coast LLC, third party defendant.
We get everybody? All right. Should we do the easiest stuff first?
Yes, sir.
You all can sit down. So,
Your Honor.
oh yeah, go ahead.
Good morning. This is Kristen Fabella appearing remotely on behalf of Speedy Mart, Pro Hoc Vice.
Good morning.
Thank you.
Yeah. Anybody else on Zoom for this real water case? Okay. Not hearing anybody anyway. Oh.
Motion, page 12.
Yeah, so which one's that? United's?
Yes, the joint motion for good faith settlement.
Go, anybody? I know nothing's been filed, but does anybody oppose defendant United Natural Foods West and WFM's Whole Foods and Plaintiffs joint motion for good faith? Nope. Granted, for all the reasons, prepare a detailed order, incorporate your arguments into the order.
Very good. Thank you, Your Honor.
Thank you. We got another one too, I think.
Yes, Your Honor. We have plaintiff's motion, the Williams twins, the two Williams babies motion for good faith with regards to Speedy Mart.
Anybody oppose that? Not hearing any opposition, so plaintiff's motion for determination good faith settlement between plaintiffs Santee Larique and London Williams and Speedy Mart on OST granted for all the reasons detailed in that motion, or detailed order, put all the reasons in there. Oh, okay. At the end of here today, don't let me forget to talk about I don't know, 93 best count, maybe 93 motions in limine and 18 motions for summary judgment, give or take. We'll talk about those, but remind me in case I forget. So I've reviewed a lot of stuff. Costco's motion is for separate trial for Layla Cave. Briefs on that. Milwaukee Hanna. Joint motion to sever. Yeah. Oh yeah, so reply. I did get Costco's reply. I forgot to say plaintiffs combined opposition. Is there another motion pending for today, or is that all of it?
So Your Honor, on that Hanna Milwaukee front, there are actually two motions.
Okay.
One
Yeah,
is-
okay,
One is to sever the individual plaintiff family groups from each other, and one is to sever Hanna Milwaukee from the real water defendant for trial. So there's two separate motions pending.
okay, that's probably what it is. Family unit one. And yeah, okay, so the family unit one and the it's my characterization, but and the meter from the water one, essentially, okay. I was like, I think, okay, so I reviewed both of those two. Cut to the chase, I'm probably inclined to keep us where we're at and go forward, but probably hear from the defendants, you know, in whatever order you want to go in's fine, and then from plaintiffs and combined opposition to everything, I guess.
Your Honor, if I may, I think,
Yeah, sure.
we'll go ahead and deal with the Hanna Milwaukee motion to sever from the real water defendants.
Okay, so I got that one right here.
And I did not see an opposition to that motion. I'm not sure if we just missed it or if there was nothing filed.
We filed the combined opposition.
Okay,
Yeah, so the opposition filed April 3rd, I guess.
all right. So, Your Honor, I heard your comment earlier, which is this, you referred to this as, I guess this was our case, the crazy case.
That's very astute of you.
I didn't get a sense that the other cases were in the crazy category, so. I'm
I
hoping-
mean, those med mal ones might be, but not quite to this level, maybe.
I'm hoping to perhaps make this case a little less crazy
I like it.
for trial.
I like it.
And I just want to start with, you know, sort of the core issues here regarding severance of the two defendants. And if you, you know, looked at our motion, we referenced the sort of 5 different criteria that Nevada Supreme Court's looked at in dealing with this issue. And several of them overlap in my mind, at least. And one of them is same occurrence in transaction. The other one has to do with common issues or common questions of fact and law. And then the 5th one is, you know, common witnesses and documents. And so I guess I want to treat sort of all of that together, because from our perspective, these are very different cases in the sense that you have a company, Real Water, who bought meters from Milwaukee that were part of that company's manufacturing process over many, many years. And that the Real Water employees have been deposed, many of them, and have testified about their experience, their knowledge, their use of these meters over time with different batches of Real Water. Okay? And so when you are talking about a failure to warn claim, we really have to focus on what's the failure to warn? Well, it's the failure to warn the Real Water employees of the proper functioning and instructions, warnings of how to use the meter, okay? That is a very different analysis, and those occurrences are very much different than move forward 2 years or move forward 2 months or who knows where along that timeline where you've got individual plaintiffs who are buying water from either retail or they're getting it delivered to their house or their job site. So the occurrence transaction are two wholly separate things. One has to do with acquiring the meters and using the meters in the manufacturing process. And the other one has to do with plaintiffs who are buying not the meters, but buying the actual water and consuming that again over different periods of time. The common questions and of law and fact are now very much different than in the first Gallagher case, at least one that was getting worked up, because now we have Real Water who has basically conceded causation and liability.
So let me pause you and chime in there. I get that point in terms of, you know, when the first is Gallagher, the first one, yeah. So when that's gearing up, you know, and this is me not having been involved at all, but you know, when your argument was gearing up, you know, everybody's disputing essentially everything, and then you know, at some point, I guess shortly before, and correct me if I'm wrong, because there's a lot of detail, but was it shortly before trial that they conceded, or during trial? I can't remember.
These guys know better than I was not involved in the
Okay,
first trial.
okay.
I believe it was within a few days before trial, but after
Right, just before.
motions eliminated.
Correct.
Okay.
On the eve of trial.
Yeah, so and probably doesn't matter too much, but you know, in terms of which exact day, but yeah, shortly before, right before that first trial, Real Water concedes liability.
And
Which is, you know, an obvious change of the landscape. But the counter, I guess, in terms of, you know, the plaintiffs raise, at least in part, is, you know, the Judge Hardy should stick with what Judge Al's already ordered, and hey, this is quote unquote, generally speaking, untimely in terms of we're already gearing up, etc. And so in terms of timing, I could understand, you know, Gallagher changed the landscape, but wasn't that some time ago? And why are we here now on the eve of my trial?
Well, you're here now on the eve of trial for a couple of different reasons. One is there's been a lot of discovery on the individual plaintiffs' cases, which have raised a lot of issues where the differences between the individual plaintiffs have become much more evident. Usage, you know, condition, disease, what they're complaining of, all of those types of issues. Now that really is the second.
Yeah.
That's really the second motion. But that in large part. And then with respect to the meter defendants separating from Real Water, it's just a matter, Your Honor, candidly, of a switch of counsel. We were brought in very late last year, and we've been working this case up. And now when we get to a point of trying the case, we're looking at it going, how can we possibly try a case where one defendant is saying we concede causation, and I get up behind it and say, no. That is hugely prejudicial. And I'm not to the prejudice part of the argument yet, but also just focusing on the common issues of law and fact, that piece of it, they're no longer contesting all of that. They're not even common issues anymore. They are not contesting medical causation. They're not contesting the presence of hydrazine. They're not really contesting how hydrazine even ended up in the product. Whereas we're contesting all of that. The trial against, if you just focused on Real Water, is basically going to be a very short trial on damages and punitive damages against Real Water. It's much different than if you bring in a parade of experts to talk about the hydrazine formation, the MW 500 probe, whether it was defective, the warnings, whether they were adequate or not. All of those involve a lot of different expert witnesses that are not involved in the Real Water trial. So from our perspective, Your Honor, those common issues of law and fact are not present in the current state of the litigation. And then finally, again, the fifth element is the witnesses and document overlap. You've got totally different witnesses with respect to the usage of the MW 500 and how it performed. None of that's relevant in the real water trial. The real water trial, that doesn't make it a bit of difference. So now I want to switch to just talk a minute about the prejudice, because I've referenced it already. When you have a co-defendant who is conceded the plaintiff's theory of liability and who is going to get up in opening, and we saw this in the Hunwardson case, which was the second trial, but won't reference specifics, but the individual attorneys get up and say, in effect, we're taking responsibility. We've admitted, causation. All we're here for is to determine damages. Okay. The plaintiffs are saying, yeah, well, Real Water should get credit for that. They've now stepped up to the plate. In effect, they're the good guys, which by implication, if not directly, is saying we ain't the good guys. Okay. And I think that's just hugely prejudicial to have that in the middle of a case where we are contesting all of those causation issues, and they're not. And finally, I want to just focus a minute on the judicial economy piece of this, okay? Because I always hear that thrown in the face of these types of arguments. The Supreme Court actually says judicial economy and settlement, facilitating potential settlement. Okay. Now, I'll just start with the plain statement. And there's plenty of law that establishes this. You can't buy judicial economy at the price of prejudice to a party. That ain't a trade-off. You don't get to say, well, we're going to save some court days here, but you guys are going to get just a little bit, screwed over. Excuse my language, but that's not the trade-off that the law requires. The law requires there to be an analysis of is there prejudice or not, and then it requires this economy consideration. And from our perspective, Your Honor, you have to throw in the other piece of it, which is the potential facilitating of settlement. If there is a trial that's a clean trial against Hanna and Milwaukee, and there has not been one so far. The first one, again, we had the Gallagher case where there was a concession. We also had Judge Williams, who imposed liability against Hanna as a sanction on in the middle of trial. So we have not actually had a jury determination of the issues against Hanna and Milwaukee. And we think that if there actually is a clean trial that's not loaded with prejudice by a co-defendant admitting liability, there's not a sanction imposed, et cetera, that's going to allow the parties to say, okay, what are these cases worth? Are these cases something that should be valued at X or some exponential number of X? So, I mean, Your Honor, I'm not sure how many mass tort sort of situations you handle, but the concept of a bellwether trial where you actually get trials that are representative of the other cases is hugely important to the parties because it allows them to properly analyze what's a case worth that's not sort of loaded up with all this other junk. So with that, Your Honor, I'll ask if you have any questions. I think that's the core of our argument.
Not on that one. I already asked the one. Does anybody want to speak on that one before we get to the other two defendant motions, I guess?
Do you want to take the other two defendants and have a plaintiff respond to all of it, or would you want them to respond?
Yeah, I want plaintiffs to respond to all of them at the same time. So if anybody has anything more on this, what I'd call the meter from the water, then we would get to the other two defendants' motions.
Your Honor, again, James Kilroy for Milwaukee. I'm going to handle what we're calling the plaintiff motion to sever. And that would be, I think, what you call the family unit. Motion to sever.
Fair with me, just
sure.
Yeah, all separate family units is how I characterized it. Okay.
So, Your Honor, starting with maybe picking up from where Mr. Evans left off, let me answer the question that you asked. Just repeating what he said, why now? We had this in front of Judge Alpha. The answer indeed is discovery has elucidated and clarified the differences in the plaintiff group. Now, if we were just talking about 13 plaintiffs with different injuries based on use of same product, that's still complicated, but we wouldn't be filing a motion to sever. The issue here is more complicated because we don't just have that complicating factor. We have what, in my view, is the biggest distinguishing factor that justifies severance, which is different batches. And let me elaborate on that. We're not talking about a single immutable product, right? It's not this model of car with many different plaintiffs who suffered many different injuries. We're talking about water that is manufactured over time in batches. And in my view, the fact that we're talking about batches is what makes this incredibly complicated to batch all the batches together, if you will. And we know that it's about batches because plaintiffs understandably.
There's a super bad batch,
Well,
right?
that's where I was going. We know this is about batches because plaintiffs understandably have presented and will present at trial a story about a super bad batch, which sure looks super bad. But the reason that's identified and isolated as super bad is it's different, it's extreme. And again, going to how our clients, the meter defendants, fit into this, and this may be unnecessary, but for my benefit, I'm new to this group.
So I'm not the only one.
Right.
Okay.
We didn't sell any product to the plaintiffs. Our product, this MW 500, is a meter,
Oh, yeah.
which
No,
is simply a measurement device. It does not measure toxicity. It doesn't measure the presence of chemicals. It measures, I'm oversimplifying this and will be corrected, but electrical currents. So there's no allegation that plaintiffs were injured because of electrical currents in water. The facts are that is what we do. Real Water used our device, our measurement device, in their manufacturing process. And as to the super bad batch, somebody employed by Real Water did a measurement, determined that the electrical current ORP negative readings weren't exactly right, and took it upon himself to pour in concentrate that we will hear at trial is rocket fuel. It's hydrazine. It's extremely toxic. Why? To try to get the measurement in their mind at the right negative OPR kind of rating. Okay, that's an isolated incident, and it's a horrible incident, and totally understand why the plaintiffs want to present the super batch. But the very fact that they want to do that, doesn't that explain why we need to be careful about severing the case? The rationale for severing on the family unit basis is, even knowing, and we pointed this out, even within the family units, there are different consumption histories, injury histories, but what we have in common, and the reason we're focusing on the family unit, is at least we can isolate when the product was purchased. Okay, family, and we've got all the names, and I've explained the differences in our brief, but each family has a history of when they purchased the product. Extremely important when you just go back to the plaintiff's story that they'll tell at trial. Super bad batch. Some of these plaintiff families didn't even purchase the water. And again, it's not an immutable product. It's not the same for the entire period of time. So in our view, even recognizing that there may be difficulties for the jury because of different types of injuries within the family unit, that is the most common in terms of common legal issues. That's the least prejudicial because, let's face it, you know, the super bad story is going to get traction. And I presume that is why the plaintiffs want to present these cases together. And there's no reason to assume that all of these batches were super bad. If they were, I think we'd have a different pleading. So, Your Honor, unless you have any questions, I think that's my argument for a severance on a family unit basis.
Thank you very much. Cavay, is that the one you're arguing?
Yes, Your Honor.
Okay. Bear with me a second. Remind me your name again.
Kevin Rising from Costco, Your Honor.
Okay, there we go. Okay, go ahead.
Your Honor, I think this is pretty fairly well briefed, in pretty great detail with a lot of exhibits that we attached to give you a sense of the evidence that supports our position to separate Layla Kava's trial from the other 12 defendants or 12 plaintiffs in this case. As we said in our brief, one of these plaintiffs is not like the others, and Layla Kava is very different. And I want to go through 3 ways in which she is very different, and that is material and creates issues of prejudice and issues of waste of time, and that I believe it's going to create a whole trial, separate trial within a trial that's going to either get lost or it's going to become the focus of the trial because it's complicated.
Subsumed, perhaps.
Subsumed, yeah, that's a good word. Thank you. First of all, something that wasn't in our brief, and this is why it's evolving. There's this claim that these are this is essentially a motion to reconsider, and it's a late motion. All of the expert discovery and most of the fact discovery that relates to her specific diagnosis and her specific disease and causation has just come to light in the last few weeks.
Oh, this was definitely
at the end of discovery.
Okay.
But something that I just learned last night.
Oh, okay,
As we were.
It's like, I know I read about that stuff.
Yeah, that's not in the brief.
The last night.
Yeah, which was filed when I was reading the real water defendants' motions in limine, is that the real water defendants are admitting liability and causation to every plaintiff except for Layla Kava. And as to Layla Kava, they are not admitting causation as to Layla Kava. And that makes sense because she has a very weak causation case. And in our papers, and it's kind of just a further theme on this, but I think it's very strong. I'm not seeing in a mass tort case or in a consolidated case where you try claims where one plaintiff, where some plaintiffs, the manufacturer of the product has admitted liability and causation, and then another plaintiff, they're not, they're contesting causation. That in and of itself, if you think about how that plays out, that is highly likely to confuse the jurors. And she gets a benefit, and we cite Rubio versus Monsanto Company in our moving papers at page 14. And that's a case from the Central District of California, federal case. But there the court says, and the issue there was the two plaintiffs that they severed the claims of 2 plaintiffs alleging that they had developed cancer as a result of a defective herbicide there. That is because of complicated causation issues. And it was specifically that one plaintiff had a much better case, a causal connection between her cancer and her use of the herbicide than the other one. And the court says, and I quote, by trying the 2 claims together, one plaintiff, despite a weaker case of causation, could benefit merely through association with a stronger plaintiff's case. But here, it's indisputable that there's a stronger causation case against the other 12 plaintiffs because the manufacturer has admitted causation. The manufacturer of the alleged defective product has admitted causation as to the other 12 plaintiffs, but not as to Layla Kava. So it's clear. It can't be argued that she doesn't have the weaker causation case, and she's going to get the benefit and be subsumed in when they argue that the causation has been established for the other plaintiffs in this case. She kind of gets this ride along, and the jurors are likely to be confused by that and give her the benefit of the doubt because you have these other plaintiffs for which the manufacturer is admitting causation. Now, why is the manufacturer, who I believe they haven't told us why they're contesting causation, but I think it's because Layla Kava is different. She has an entirely different diagnosis, and we lay that out in our papers. But I wanted to just give you some kind of color on that. Out of the sum, as I understand it, 90 plaintiffs in real water cases, Layla Kava is the only plaintiff seeking compensation for injuries due to autoimmune hepatitis.
I'm not aware of any, and maybe plaintiffs can point something out, but I'm not aware of any other plaintiff that is seeking damages for autoimmune hepatitis. It's important because autoimmune hepatitis was in the broad definition that the CDC used when they investigated. They had the public investigation report, and they were looking for victims whose injuries were probably caused by the consumption of real water. They excluded people with autoimmune hepatitis. They made a determination that they weren't probably affected by the consumption of real water. Now, like all autoimmune diseases, AIH is a highly complicated genetic disease. It's difficult to understand by itself, but it's honestly per se confusing and prejudicial when presented with drug-induced or direct toxic liver injuries. First of all, everyone agrees that Ms. Cava was genetically predisposed to AIH. Some plaintiffs' opposition at page 8. Their expert agrees, her treating physicians agree, our expert, Dr. Brown, agrees. They all agree that she had zero chance of going through her life and not getting AIH. She was genetically predisposed to get AIH. Her AIH was waiting to manifest itself. And what it did, and how it did it, is it did so as expected, around 6 years old in girls. Classic presentation of type 2 AIH. It often happens when they start school, which is when she first became sick, and are exposed to an avalanche of new germs. It's chronic, it can be managed, but does not go away. Plaintiff's theory here is that consumption of real water was an environmental trigger and not a direct cause of injury to her liver. So essentially, when their expert describes this, and he has to do so, he has to rely on 18 different articles and a changing and evolving diagnosis. He started out saying she just had AIH, and then he said she has AIH, but it might be a drug-induced liver injury like AIH. And he's gone back and forth, and he's danced back and forth. He has a rebuttal report only as to Ms. Cava. Now, there can be environmental triggers for AIH, which can include viruses. She had multiple ear infections, bacteria, even allergies. So unlike the other plaintiffs in the case, who are essentially alleging a drug-induced liver injury, which is a little bit of a misnomer here because it's not a drug, it's a toxin. They're alleging that they ingested a toxin, it went to their liver, it damaged their liver.
So you said there were 3 different things, right? 3 different points?
Yeah.
So we're still on the first one?
This is the second.
Okay.
So, and I should give given you a road.
Okay, so what's one is what?
So one is they've admitted liability and causation as to all other plaintiffs.
Okay,
She's the
gotcha.
only plaintiff.
And then 2 is this
for
genetic.
contesting liability.
Okay, 2 is the genetic
Is
disposition.
she has a different diagnosis that has a different causal pattern
Gotcha.
that is much more complicated and is really the subject of the battle of the experts from a medical causation standpoint.
Okay.
As well as takes a significant amount of time and testimony from treating physicians, because they have to explain the differences between drug-induced liver injury and autoimmune hepatitis. And in so doing, to get to autoimmune hepatitis, you have to rule out a drug-induced liver injury. So it's so different, Your Honor, and it's so complicated that it is highly likely to confuse the jury and be prejudicial to Costco. Well, keep in mind, Costco is a retailer here. Costco is just.
I'm quite familiar with Costco.
They do, but from a level of culpability in a case like this, they sold a product, right? So the third thing is,
Okay.
and the third point is essentially the timing issue that we talked about in the batch issue, but with Leila Cava, it's even more pronounced. So her onset of symptoms and her consumption of real water that they allege caused her autoimmune hepatitis occurred in 2018. All of the other plaintiffs here, their consumption and their injuries occurred years later. So it's not just individual batch, it's 2 years removed from the super bad batch. And there's no evidence, there's no testing of any water from real water from 2018. She and her family, she has autoimmune hepatitis. Other people in her family, friends, family members drink real water. None of them had any symptoms. None of them had any reactions to it whatsoever. There's no evidence of that. There's sorry, I lost my train of thought there, Your Honor.
The last thing he said is, no other family members had any, well, you had said before that, no testing this water. No other family members have any symptoms.
Yeah, and it's 2 years removed, Your Honor.
Right.
It's 2 years prior to the super bad batch, but it's going to be tried with most of the plaintiffs whose consumption and injuries occurred, and including 5 minor plaintiffs who have diagnosed liver injuries, who had to be hospitalized, who were the catalyst for the investigation and the recall of real water. So to try this plaintiff who the manufacturer is actually contesting causation, who has a completely different diagnosis with a much different causal chain that's incredibly complicated and likely to take up a lot of time and battles between experts that aren't going to occur between others. And the consumption of the product and exposure to the product that's far removed in time. To try her with the others is incredibly prejudicial, and it will be a waste of time and judicial resources. At the end of the day, you're talking about removing 1 plaintiff out of 13. The risk, given what I've laid out, that there'll be prejudice, it's also a waste of judicial resources if we have to try 13 cases over again, because the inclusion of 1 prejudices the whole bunch. And she is, as I said when I started this, she is not like the other plaintiffs. She's significantly different enough that her case not only should be tried, but deserves to be tried, so that we can get to the truth of how Costco can have a fair trial. And we're not trying to delay it, Your Honor. We'll take the first available.
Yeah, I mean, I saw that, I appreciate that argument. The reality, if I were to grant this motion, I mean, it's not going to be tried at the same time, but I get what you're saying.
Yeah, we're not afraid to try the case, Your Honor. We just want to try it fairly, and we'll try it as soon as you'll let us.
Well, thank you very much.
Thank you, Your Honor.
Anybody else on the defensive?
Yeah, we had a jointer on that. I'll be very quick because I'm probably gonna get a parking ticket if I don't. We joined into the Kava motion to sever. But dovetails with our other motions, especially with the family units. But I'll give, first of all, before I start, did you see our reply brief that we filed yesterday? Because one of the questions you did
I
ask.
saw Costco's reply brief.
Okay, we filed it in the morning about 10:30, and it addressed one of the questions you raised at the very beginning, why now? And we, talked about Rule 21 that can be at any time, but that's in our brief. You can look at that, Your Honor.
Well, let me at least,
Look at it.
yeah, I mean, it's kind of hard sometimes, but yeah. Have to scroll through multiple pages of Pending hearings. Okay. What, do you happen to have the document number?
I don't have the document number with me. It was filed about
What was
10:30
yesterday?
yesterday.
Hopefully it was yesterday.
Yeah, I've got a clean copy if you'd like me.
Oh, sure, yeah, if you have it on paper. Oh, maybe you're-
Approach on?
Sure.
Just on page 4 is where we set the rule.
Okay.
I didn't
Okay.
want to distract that much. It's to raise, just to answer your question of why now
Mhm.
we're allowed to do it, at least under the rule, to any time. So, but I want to get back to Leela and really get through this quick, given the time. One, Leela does have different presentation as we were told by Costco's counsel. And what I would like to take another look is not only is that different presentation, her own symptoms, but as we talked about the different batch, but talking about her, whether you take it as autoimmune hepatitis or you accept plaintiff's definition of at least one iteration of drug-induced autoimmune-like hepatitis, both would be excluded under the CDC's definition when they did their analysis because it's not idiopathic. And so that makes it different from the other individuals that have to be, that allegedly will get into at least the association. As you know, Your Honor, association is not causation, but it further removes Leela. The second point about Leela is that her presentation is a little different when it talks about consumption, at least, and I'll just take two plaintiffs or two groups of plaintiffs that are different. Leela consumes real water, allegedly. She gets this manifestation of autoimmune, or whether you take plaintiff's view of drug-induced autoimmune-like hepatitis. She stops consuming, she continues to have this illness. You take the father, Wren, and you take the William girls, both allegedly consume real water, both got sick. There's no allegation. They both had liver function triggered. They get better, and then they continue to consume real water afterwards and did not get sick. That's another difference between Layla and the other individuals, and also dovetails with Milwaukee's argument earlier today of why there are some differences between these people. Third, because Layla has this autoimmune hepatitis, one of the arguments that plaintiffs will use, especially used during trial, is they will trot out a video, or maybe they'll bring Blaine Jones and deposition testimony of he would not go through this for $10 million. Well, he's assuming he has this illness and got sick and did drink real water. That is different than autoimmune hepatitis. And severing out Layla prevents the prejudice of that argument. Now, that argument is prejudice no matter what, and a reason why we should grant the other motions to sever. But that is specifically to this case why of having this argument of Blaine Jones is I would not do this again for $10 million. Well, Layla's not in the same kind of illness presentation. And then finally, because Real Water has decided not to contest causation, having this severed out at least will eliminate one of their arguments that they have repeatedly said, and that's in Gallagher post-trial motions of how prejudiced they are by the existence and the arguments of the meter defendants. So severing out Layla allows us to at least avoid this argument that we will hear from Real Water's counsel that because we've omitted now a month or two before the trial, that we are liable and we caused everything. Anything the meter defendants say prejudice us. Well, severing out Layla avoids that issue that Real Water has presented in their briefs here. They presented in their post-trial briefs in the Gallagher cases. We're trying to get that ready for appeal. And that severing out Layla helps that.
So I'm not sure I followed that last one. Say, go through that one again.
They're arguing that since we are, and I don't, to be honest, I don't understand the whole argument because causation, there's many different levels of causation. Their argument is because they are contesting and saying how bad Real Water is and contesting the process,
They meaning you get.
You,
the
us, the
instrument
meter,
people.
the instrument people contesting, when we've already fell on our sword, you're gonna have jury nullification, this prejudices us. And it shouldn't be allowed to be argued by the meter instrument defendants. If they are not conceding causation, that argument will not be there. A reason why we should still sever out Layla. It's also another reason why we should sever out the instruments from real water defendants. But those are the 4 points I wanted to raise, Your Honor. Sorry to go maybe a little longer than I want, but I want to raise those of why our jointer into the Cave severance.
Oh, thank you.
Your Honor, told you about the blue water. We didn't take a position in this motion. But in the filing last night and the argument of counsel just now, that is completely incorrect. The argument that we made in the Gallagher trial was that the meter defendant, in particular Carl Savaggio, lying to the jury was prejudicial to the defendants. They took that argument out of context. They put a quote by me at the end of their brief last night out of context. And I just wish that they hadn't done so, because I feel I need to correct the record. That is not a complete excerpt that the court has. My statement was in regards to Carl Savaggio being one of the meter defendant principals being found by the judge to have, let's say, not completely told the truth. I believe he lied to the jury and was called out for that in cross-examination, Your Honor.
So let me ask you, since you're in the quote unquote hot seat now, and in all candor, I have not seen whatever it was that was filed, last night, or the reference was, real water is not admitting causation to Layla, is admitting causation as to all the others. Are you saying that's not correct?
That is correct, Your Honor. We have not admitted causation as to Layla Kaveh at this time. There are a number of pretrial motions that this court will hear that will impact a number of decisions a number of parties make. There are evidence that may or may not come in, may be excluded, and we will undoubtedly revisit those issues.
Okay, gotcha.
But I just felt that it was not fair to file something, last night saying, well, Real Water said X, Y, and Z when it's taken out of context.
Oh, so I may have totally missed whatever you're concerned about, but you're confirming, what I focused on was a statement or argument, Real Water's not admitting causation to Layla, is as to all the others, at least at this time, and you're saying that, at least that statement's correct.
Sort of, and I apologize, Your Honor. Again, we weren't party to this motion. People are speaking for us and getting it not quite correct. We've admitted causation for the 5 babies. We've disputed causation for like Rudy Morales as an example. We've disputed causation for Layla Kaveh. We've disputed causation for the parents. Those are in separate motions for summary judgment that are before the court. So there are complex issues before the court that will be decided as part of and I counted on 99 motions to eliminate, 2 motions to strike, and 19 motions for summary judgment. So we have 121 matters currently pending before the court besides these motions. And it will all come out in the wash, Your Honor. And I'm sure plaintiffs will clarify the record as they need to.
All right, thank you very much. So let's work backwards, I guess, is probably in terms of what I'm most interested in hearing about, and this will apply for the rebuttals as well. Why shouldn't Layla Kaveh, or apologize to her family, how do you say Kaveh? Why shouldn't she be separated out?
Well, Your Honor, the answer is very simple. Her claim is no different than any of the other plaintiffs in this case. They all allege the same exact claim, same theory of causation that they purchased and consumed real water, that the real water was defective due to the contamination of hydrazine, which is a rocket fuel and known liver toxin, and they suffered liver injury as a result. Leela Kava purchased real water from Costco. She drank real water. The real water was contaminated with hydrazine. She was exposed to hydrazine and she suffered liver failure, just like every one of the other plaintiffs who allege, or the other 5 babies in the same case. The only minor difference with respect to Leela is in addition to her liver failure, the hydrazine exposure also caused her to develop onset of autoimmune hepatitis. It's a rare instance. Some people have it. She had a genetic predisposition for autoimmune hepatitis. She did not have autoimmune hepatitis. Previously healthy, no liver issues, no problems until she started consuming real water in August of 2018 when she's 6 years old. In October of 2018, after drinking real water daily for approximately 2 months, she's hospitalized with liver failure and is also diagnosed with autoimmune hepatitis. This different specific medical issue with respect to Leela is not a basis to separate a trial and essentially duplicate the exact same trial in this case twice. In fact, it was the same exact issue that was before Judge Alf when she consolidated these cases. When we asked for consolidation, every one of these defendants, save Real Water, opposed the motion. And they made the same arguments they're making today, that plaintiffs' claims arose out of different transactions and occurrences because they purchased real water at different times and different stores. They involve different questions of fact and related to their specific medical histories and specific individual causation. And that consolidation wouldn't promote judicial economy and it would be unduly prejudicial based on the same bald speculative assertions of prejudice that have not been borne out ever.
So, give me a moment to think of how to articulate a question or concern, specific as to her, a lot of what you're arguing, applies on this general broad basis. They all drank real water. They all, suffered liver damage, failure, however it is. These general broad kind of arguments, which goes back to why, I wanted to start your argument in opposition focused on her, because, I think I agree, subject to rebuttal in my actual order, that a lot of this, it's hard for me to say, well, Judge Alf got it wrong. But on her, there's all these, at least what they argue, all these distinctions, very specific issues, and you're painting with a very broad brush. So for example, and they argue about timing too. So after my soliloquy here, tell me about actual specific, why is she the same as everybody else? Because it sounds like she is quite different. And then timing, and this goes probably to some of my unfamiliarity. So the expert rebuttal report, where defendants argue, at least in part, that it was and I may mischaracterize some of what they're saying, but, you know, this rebuttal report was specific as to her versus anybody else. When was that rebuttal report produced to the defendants would be a question I'd have. That's a specific question, if anybody knows, feel free to answer.
Well, let me address your questions, Your Honor. So you're right. I did start off broad. And the reason I did was because I want to get to the actual law on this issue, which you didn't hear anything from the defendant's arguments. Because what the law actually provides, Rule 42 states that consolidation is appropriate if cases involve a common question of law or fact. They don't have to involve every single common question of law or fact. And there certainly can be differences amongst the individual plaintiffs. In fact, there has to be. Every plaintiff is a specific causation.
Again, this goes back to my concern though. So you're like, as I sit here right this moment, I'm likely not going to grant anything else they're asking for because of what you're saying. But, you know, I have wide discretion, you know, I'm fairly familiar with the law of a common question of law or fact, but then you have to account, you know, to use the phrase that the Nevada Supreme Court employs quite often, totality of circumstances. So when I'm looking at, you know, all these different points specific to her, and maybe I'm repeating myself, so I apologize, but
No, I understand.
I'm not.
Let me be more specific.
Okay.
The difference between her claims and the evidence related to her separate medical issue is minute. It's our expert who gives the opinion, the causation opinion on all the plaintiffs is the exact same. So his testimony related to Leela is just an extra amount of time on the stand, maybe 30 minutes or less than an hour, I would estimate. Of all the experts, and there's nearly 30 who have been disclosed in the case, there is one expert, a medical expert provided by Costco, who relates to Leela Kava's condition. That's it. Every other expert is either generally a generic expert that it testifies to, you know, every generic issue in their scope in the case, or they give opinions as to all the plaintiffs. So we're just talking about any one plaintiff that is separated from this case. You're talking about saving hours of trial time related to that issue. And when you're looking at that question, it becomes a question of judicial economy and prejudice. Is it these differences, which are in every case worth duplicating the trial, largely duplicating the trial to save those couple amount of hours of testimony that are unique to each of the plaintiffs, including Leela Kava. And that's what, you know, the law that has addressed this, they've consistently recognized this exact situation. I'll cite to the, on page 9 of our opposition, the 11th Circuit decision in the Ignium case. Quote, although each plaintiff's proof of causation was necessarily different, generally.
Sorry, I apologize. Where are you?
On page 9 of the opposition.
That's what I thought, man.
The 11th Circuit rejecting the same arguments they're making here on these differences and, you know, specific causation and the same exact arguments that they're making. 11th Circuit rejected it and said,
Oh, yeah, but
that's not enough.
Up at the very top.
Yes.
Gotcha.
And then the Johnson & Johnson talc case. As defendant's brief describes, they have a host of differentiating characteristics. These differences include their genetic dispositions, family histories, previous diagnoses, ages when they developed ovarian cancer, types of ovarian cancer, and durations and frequencies of talc use. However, the existence of facts unique to each plaintiff does not preclude joinder. It's the same here.
So the last part of that was from the Missouri Court of Appeals opinion. Wrong?
Correct. That was the Johnson & Johnson talc case. And Your Honor, if I can direct your attention to page 12 and 13 of our opposition, we cite several more cases for this same exact position that yes, every product liability case that you're going to consolidate or join together, they're going to involve some unique issues related to medical histories and causation. Just like with Leela, same claim, injured by real water, suffered a liver injury, but the extent of that liver injury is a little different than some of the other plaintiffs. The question becomes, does that difference justify a whole nother trial in her case? And the answer is no, because when you look at the governing standards, judicial economy, we're going to separate one case and have another 4-week trial, summon another couple thousand jurors, go through several weeks of the same evidence, all relating to real water and how they produced the hydrazine, how it got in there, the toxicity of hydrazine, the production process, the meters involvement, all that stuff is exactly the same. The only difference between any of these individual cases is the individual plaintiff and the extent of their medical injury and damages. And as I said, there's one different expert related to that, and that's just now. We have a motion that we think that this expert isn't even qualified to testify on these issues. So these are uncertain issues related to this trial. So it may even be fewer than this, but at the most, we are talking about a couple hours of different a couple hours of extra trial time that wouldn't already be there versus weeks and months, if not of judicial economical time that's saved. I mean, it's not just these trials, it's the trial time, it's the pretrial motion time, it's the cost. Your Honor, I would be remiss not to mention that this isn't the first time that we're doing this. And I think that's important for a couple reasons. Number one, because a lot of what you heard today were just simply inaccurate statements about the history and the prior trials and the issues. I'm not going to burden the court's time by going through them all and trying to address them, but suffice it to say that there was a lot of inaccuracies in what was told to you. And to be fair, they are all new in this case, but we have done this twice. The 12-person Gallagher trial, that involved a lot of unique plaintiffs and a lot of unique medicals, a lot of unique injuries. That case involved the death case. All in the last case, the Hunwartson case, 5 plaintiffs, also involved unique experts. That involved the liver transplant case. That was a main issue in the case that was different than the other 4 plaintiffs. And there was necessarily more and additional testimony and evidence related to that claim. But it did not overcome the vast amount of time and money that was saved by trying those 5 cases together. What we know from the prior 2 cases, these are very expensive trials.
So let me follow up on that point. So, you know, if the argument is, you know, well, we tried X number of plaintiffs in Gallagher, however you say, we tried X number of plaintiffs, and what's the name of the other one?
Hunwartson.
Say that again.
Hunwartson.
Wardson?
Hunwartson. HUNWARDSEN.
Okay, trial number 2. your argument can't be and is not, but here's where I think we're on this, kind of slope, kind of discretion thing, like, if the argument's, hey, we can't, judicial economy, cost, well, that can't be the end all be all, because you've already tried 2 other cases and here you're on the 3rd. So I'm trying to think of how to phrase that as a question. But your if judicial economy and costs were the end all be all, then we'd only have 1 trial with 500 plaintiffs. Obviously, that's not what has happened, is not. So how is it that, judicial economy as to this particular plaintiff is, the end all be all as you seem to be arguing, I guess is the question.
Well, I think that's a good question.
Thank you.
And really, if we could have one trial with all the plaintiffs, if that was practical, then we would love to do that. But what we've seen is it's not practical to have that many plaintiffs combined together. And that's consistent with what the case law says, including case law cited by defendants, where they try to say, look, the cases don't support it, because when you get to too many plaintiffs, it does start to become too much in the courtroom. And so, but what we have done is learned from the first 2 trials. The first one was 12. By the time the second one came down, we realized, that was a manageable number and we could go in that range or even a little bit more. It was too soon for the second one, which it was set right after the first one ended, essentially. But for this case, we moved to consolidate more together to get the reasonable amount of plaintiffs that we could try them together in one case, be as economical as possible. And we've done that since. Judge Williams just consolidated 3 of the other ones. That's going to be a 15 plaintiff trial. That's going to be the one after that. We have a pending motion for a preferential trial date in October of this year, which would be the next case we would try. And then for the rest of these ones that we still have, we are making every effort to consolidate them to have as few trials as possible. Because what we've seen from the first 2 is, even though one involved 12 plaintiffs and one involved 5, they both took about the same amount of time, approximately 4 weeks. They both cost about the same amount of money, in the neighborhood of $1 million each. And that would be the same if you were to separate Lila Kava's case. Her separate case would still be approximately a 4-week trial. It would still cost approximately $1 million based on what these trials cost, because all the other common evidence is the same. And that would be the antithesis of judicial economy, of what we're trying to better work towards. And it would be substantially prejudicial to Lila, because it would inflict massive economic harm on her, because she would be bearing the brunt of trying only her case and bearing the cost of that entire thing. Costco, money's not an option for them. Of course, they want to separate this out. Meter defendants are funded by big insurance companies. It benefits them to try to inflict this type of economic harm on an individual plaintiff. It betters their position. So the real prejudice here would be from separating Lila Kava's case out, and it would not be judicially economical or worthwhile. And I would again point your honor to the cases cited on page 12 and 13 of our opposition, where in all these similar cases, they talk about the substantial savings of time and money that consolidation offers over the minimal differences that are necessarily going to exist in all these plaintiffs' medical histories that can easily be handled by jury instructions and verdict forms. And again, those have borne out in the prior two cases. The jury will be instructed on every issue that is unique to Lila Cava's claim. There will be a separate space on the verdict form for the jury to decide Lila Cava. Every case that looks at that has said this is sufficient to address any speculative concerns that they have. And they are speculative because they are addressed through jury instructions. And it does not warrant separating a trial and duplicating so much.
So you're on the repetition point.
Yes, Your Honor. I will finish with this. I just want to note that what you heard in terms of prejudice from the defendants was we're prejudiced because Real Water is admitting to liability on plaintiffs. And then you also heard we're prejudiced because Real Water is not admitting to liability as to Lila Cava. It can't be both. They're arguing both sides of the coin here. And because the reason they're doing that is because there is no real prejudice that's supported by the case law. I would again just reiterate that the cases cited in our opposition established that, and we think your initial inclination was clear and correct, and we'd ask you to stick with it.
Thank
Your Honor,
you.
if I just add 2 points.
So one of your points is going to be, when is the rebuttal report produced?
That I wanted to talk about that. That was one of the points. What happened is they hired a hepatologist called Dr. Brown, and they being Costco. Dr. Brown filed an original report. In that report, he said that there's no such thing as drug-induced autoimmune hepatitis. That's what he said in the report. That's why we filed the rebuttal report of Dr. Hudson, because it's pretty clear that there is drug-induced hepatitis. There's a lot of articles about it. So we filed the rebuttal report. After we filed the rebuttal report, I took Dr. Brown's deposition. He flip-flopped. When I confronted him with this article from October, which is a consensus of experts, including Dr. Andrade, who's the leading expert on autoimmune hepatitis, all of them said that there is such a thing as drug-induced autoimmune like hepatitis.
So this is a very attorney way of,
well,
so if you could answer my question, that'd be much appreciated.
the expert rebuttal report was filed, I believe, on March 1st. But it was filed in
Like
response to
March
Dr.
1st
Brown.
of
This year.
2020.
But
Okay,
it was because they brought up this issue with Dr. Brown's report that was filed before that. So we take Dr. Brown's deposition, we confront him with all these articles. And now he says, not only is there such a thing as drug-induced autoimmune hepatitis, and this is all in motion limine number 1, if you want to look at, Your Honor, but he agrees that hydralazine can cause autoimmune hepatitis. Hydralazine is different than hydrazine. Hydralazine is a commonly used blood pressure medicine, but the metabolite of hydralazine, what happens when it gets into the body, the metabolite is hydrazine. So now Dr. Brown says, oh, hydralazine can cause autoimmune hepatitis. Another drug, isocyanazide, can cause autoimmune hepatitis, which also metabolizes hydrazine. But he says, but I haven't seen any studies that hydrazine can cause autoimmune hepatitis. So that is the sole causation issue left in the case. And so they stand up and they say they're prejudiced because that is such a significant difference in causation that they can't try the cases together. Well, first of all, Your Honor, stepping back, the real reason they want to carve the Cave case out is she's going to need a liver transplant. And they know from the Hunwartson $20 million verdict that the liver transplant case is going to get more than the baby case. And we had the Gallagher verdict, baby, $6 million just with acute liver failure. So that is the real motivation here. Take the big ticket item out of the trial, try to continue it so both all of them are not exposed to it. But stepping back to the point I was trying to make, there is no difference in causation because the causation argument.
so he already talked about that.
No, but I want to get into specific. The specific causation argument is, Your Honor, can it trigger autoimmune hepatitis? Or the same rocket fuel that gets down into the liver causes permanent tissue damage, scarring to the liver, they're contending cannot trigger autoimmune hepatitis. That is the only issue that is added by having Kaveh to this trial. And that's probably 20 to 30 minutes from Dr. Hudson. And it's probably however long Dr. Brown takes if he's allowed to testify. So you are adding 1.5 hours to a trial to do the Kaveh case in here, as opposed to doing 2 5-week trials. And I think Judge Alf got it right because these exact arguments were made to her. Thank you.
Thank you. What time is it? Special session. It's 1:30 or special?
Yeah, 1:30.
Okay.
I'm gonna be quick, Your Honor, and I know that when judges give you hints, so I try to pay attention to those hints. Just from a date perspective, Judge Alf's decision on consolidation was in December. The expert reports, the initial expert reports in these matters were February 5. And the rebuttal report, as I mentioned, it was March 1st. The concept, and you raised this yourself, Your Honor, the concept that how can I go against what Judge Alf has already done? None of the arguments that we have raised regarding the prejudice of having real water in the same trial as the meter defendants were in front of Judge Alf. The individual plaintiff arguments were to some degree, but before all the discovery was done. They moved to consolidate before any discovery is done, before any of the expert reports are done, before any of the depositions are done. So the concept that Judge Alf has decided this issue on the same record that you have is totally incorrect. And so I don't think it's a matter of overruling Judge Alf. It's a matter of analyzing the issues given the current record in front of you based upon the law. And Your Honor, our reply brief that we filed that I've now handed up to you, they say there's no prejudice, okay? Again, one of the arguments that we heard in the closing argument is we already have a baseline of what the damage is here, $10 million. And the reason we have that baseline is because an executive of Real Water, who's also a plaintiff in the litigation, has admitted that. Well, that may be an admission that may or may not come in against Real Water. It certainly has no business being in a trial with the rest of the defendants. How is that admissible evidence against the meter defendants? It's not, Your Honor, but it's highly prejudicial because they've got a baseline, something they can hammer the level of damages. That's hugely prejudicial. The other thing, Your Honor, I appreciate Mr. Odou getting up and saying that our quote from him was somehow misleading. We've attached a copy of the transcript. The argument that Real Water made was one of their major arguments in their post-trial motion practice in the Gallagher case was we were prejudiced by the defense that the meter defendants presented to the jury. It wasn't just that Carl Savaggio lied. And if you look at the quote we gave you,
So all I cared about on that was really the causation issue vis-a-vis Layla Kaveh.
no, I understand, Your Honor. I'm trying, and I've heard what you said, which is you're not inclined to go with us on the rest of the arguments. I'm just trying to urge you respectfully to read the reply brief, because I think there are specific demonstrated prejudices that the meter defendants are exposed to if you've got Real Water in the case. And they are constantly arguing about the limitation on my ability to cross-examine their witnesses. I'm going to hammer their witnesses because I think they were incompetent and reckless. Now, are they going to like that? Of course not. Are they going to hammer my witnesses? Maybe so. I don't know. But the point is, they have filed a post-trial motion in front of Judge Williams where they specifically argued that the arguments Hanna made about hydrazine being poison and all the rest of it were prejudicial to them such that they should get a new trial. Well, it's not just Carl Savaggio. There are experts who are going to point fingers at them. There's going to be cross-examination, et cetera, and it all goes very legitimately to the failure to warn claim. It's not just trashing them. It really goes to what was the knowledge of the employees and what was their experience in using the meters. With that, Your Honor, I will rest on that motion. I don't know if Mr. Kilroy, or.
There's somebody else has some rebuttal.
Real quick, Your Honor.
And I think you pointed out what the concern is with us for prejudice at trial here, is that there's these broad brush strokes of there's a liver injury. And then when you push on it, they don't, they just skirt over the fact that it's a totally separate diagnosis. Let me read to you what their expert says about AIH.
So this is their expert,
Dr. Hudson.
Dr. Hudson.
And this is at Exhibit 6 in our papers. And it's quoted at page 10 of 19 in our opening brief.
Oh, bear with me. Okay.
He doesn't say that he never opines, that you can't find it anywhere in his report where he says she consumed real water, it damaged her liver, and then that damaged liver caused autoimmune hepatitis. What he says is it's almost certainly idiosyncratic and dependent on the presence of a specific polymorphism in one of the many immune mediating proteins that is unique to the defendant, allowing the binding of the trigger antigen and leading to a cascade of events resulting in the emergence of autoimmune hepatitis. And then as we say further, he goes on to say that Leila Kava developed autoimmune hepatitis secondary to ingestion of real water, causing an environmental trigger to start the cascade of events. And there are a number, and he admits that there are a number of environmental triggers. And he would also admit that the majority of the time, you can't find a trigger. There's no known cause of AIH. So it's a very complex disease. And the concern, and Mr. Kemp demonstrated what the concern is he's going to get up there and say, are you telling me that rocket fuel that can cause marks on your liver can't cause autoimmune hepatitis? He's trying to confuse the issues with you, Your Honor. What's he going to do with a jury who's trying to figure out what the issues are between 13 separate plaintiffs? So I think Leila Kava is different. Her diagnosis is different. The causal connection is different. And her consumption is not close in time. You got to ask yourself, why did they package Leila Kava with these 5 other kind of original liver injury kits that started the recall in the first place? Because they want to hide her in there. They want her to get the benefit of the argument that he just made to you. And that's the prejudice to the defendants, thus specifically the prejudice to Costco. And this is the only case that Costco would be trying. Thank you, Your Honor.
Thank you. Any other rebuttals?
No, Your Honor.
So let's go easiest to hardest. So let's see, the motion. So the motion that I characterized as to separate all the family units. Trying to look for the actual title, but filed on March 26th at 3:16. That's denied. I mean, for all the reasons in plaintiff's opposition, but essentially court has discretion to consolidate, coordinate, makes perfect sense to consolidate trials as Judge Alf did on that point. I'm not going to read off all the reasons on that one because that one's super easy. To the motion to sever the meter defendants from the water defendants also denied. again, it makes sense, to have the trial is currently constituted in that regard. All the reasons in plaintiff's opposition. The motion to separate trial for Lola Cavay is granted. I asked more than one time, hey, you're painting with broad brushes. What are the actual particular specific facts that tie her in with the others versus all these differentiating factors? And I'll acknowledge there are same issues, many, plaintiff focuses on many of those, but as defendants, Costco and the joining party point out, there are a lot of differences and significant material differences. So to go through some of them, the other motions are denied. Part of the consolidations to get these bellwether trials, and it makes sense to deny the other ones on that basis. It makes sense to grant this one on that type of basis and reasoning. She very clearly has a different issue with the AIH, autoimmune hepatitis, genetic predisposition, than the other ones. There's the issue that's significant, and again, it's totality of circumstances and court's discretion. So factors, these are all factors. It's not one thing or the other versus something else, but significant, Real Water's admitting to causation as to the other children, but not as to Layla Cave. There's significant differences in timing and batch, 2018 versus 2020. Some of these, I'm not getting into all the exact details, but they're set forth in Costco's briefs. The testing of the particular water at the particular time, much more closely in time as to the other planes versus Ms. Cave. There is a significant risk, significant risk of undue and unfair prejudice to include her along with all the other plaintiffs here. Significant risk of confusion. There are different causation issues. I get the argument that, general liver damage, but she is different. Judicial economy is not the end all be all. We're not nobody's understandably having trials on all the plaintiffs, so the court then is left at figuring out, under its discretion, what we're limited to. And going to judicial economy, and I think this is significant. I have full confidence that my denial of the other motions is going to be upheld. Now, half of you disagree with that, and that's understandable. But that's not the case with Miss Cave. And what I would hate to see happen is, you know, you have to do everything in this case all over again because of this one issue, which is quite significant. So there's that. Timing's fair, argument raised by defendants in terms of, hey, yeah, I am to some extent reconsidering, or, you know, this plaintiff's argument, but, you know, I am to some extent reconsidering Judge Al's ruling, but timing's significant there. That ruling came before even apparently initial expert reports, clearly before rebuttal report. I would hate for 1 or 2 hours of testimony to throw a wrench in this whole trial for every other plaintiff. So I think that favors the severance here. So be more detailed even in the order, but put those reasons in there, submitted to council for review and approval.
Yeah, Judge, can I ask one question?
Sure.
Since you've severed Kaveh out and I have a 5-year rule, I have to file an emergency motion to set it down for trial immediately. And I have to do that under some case number. So I don't know what case number you're going to give the case, because I don't know that we can have Kaveh have one case number and the remaining
So
people in Kaveh,
Isn't
that she's not the only person that was filed in that case. So it creates a procedural problem. And like I've already said, we've got real water cases stacked up. And now I've got to go find 5 weeks either with you or someone else to try this case in pretty short order. It's ready to try. So I want to file an emergency motion to set it down for trial, you know, probably on your July stack if you're going to retain the case. But I need to know what case number I should do that under.
That's great. I mean, so with the
With the
huge
sever
caveat,
case, basically you've made 2 different cases. So, I mean, the way to look at it, I think there's 2 ways to look at it. We could let Kaveh keep this case number she's got, 864391,
that's what I
by
was.
herself, and move all the other plaintiffs into the Wren case number and the carrier case number. That's fine with me. Or somewhere or another, we've got to give her a new case number or sub case number. Because if we're going to be doing trial settings just for Kaveh, I have to file the motion right away.
Your Honor, one other consideration, if you mind. The motions in limine that are coming up, all of the pretrial motions, they may have an effect on whether or not there is any other causation issues, as Mr. Odou alluded to previously. Can you defer this until those motions are heard? Because there's 2 that.
I already made my ruling on that.
It doesn't matter. When they,
I understand.
as soon as they do the order, we're going to file a motion for reconsideration.
That's fine.
But I'm more concerned about.
So I mean, the number I have is the number you just, 864391.
She wasn't the only one when we filed that case. We filed a multi-plaintiff case, and I don't know which one of the other plaintiffs are in there. But what you're doing is you're pulling that plaintiff out of that case, but she's still got the same case number. So what am I going to do? You know, and look at from the clerk's office point of view. I'm filing an emergency motion to set a trial and a case number that's set down for trial on May 28th.
So I'm not, I, to some extent,
You severed a plaintiff off, so you've created 2 cases.
No, I haven't.
Okay,
No, I haven't. I've said in this consolidated case that encompasses 3 different case numbers, right?
right. It's one case now. Okay, it's been consolidated by Judge L, so we have.
Right,
one
no,
case.
and I'm not disputing that,
Right.
but so, you know, I don't know how to answer your question, I guess.
Judge, your position will create even further problems, because if you are taking the position that she's still in this case and we get judgments for all the other plaintiffs, because we don't have a final judgment for her, does that mean I don't have a final judgment that I can take up on appeal or the defense can take up on appeal? When you sever something, it's got to go into a different action. I mean, I think that's pretty clear.
I don't know how to answer that question right now.
Judge, I have to file an emergency motion, so I'll use this case number. We'll be back here next week to.
I
set
mean,
the
you'll
trial.
be here regardless, so, yeah.
Right. And,
Um,
Judge, I think it needs some thought because it is a serious issue when. I
yeah,
have
so
five-
put it in writing for me. You know, the 5-year rule I hadn't heard anything about until after I made my ruling. You know, if that's a concern, put that in writing, see if they'll agree or stipulate if you can,
We'll
but.
stipulate to waive the 5
Okay,
years.
okay. Case number, I don't know the answer.
Yeah, Judge, I mean, this is a big ticket case, okay, so I want to go to trial. with it. So that.
Yeah, I mean,
that's why we
you have,
filed an Emergency motion, but when do I file it? That's the issue.
but right now, what I have is the lead case is A-21-831169-B.
All these cases have been consolidated. There's just one case now. There's not 3 cases. There's one. They weren't coordinated. They were consolidated.
That's why I said the lead case number that I have is A-21-831169-B.
I will file the emergency
So-
motion that case, Your Honor.
Yeah.
I think that's it, Your Honor.
We gotta talk about scheduling, well, when are you in front of me next?
I think a week from Thursday, Your Honor.
Next Tuesday. Let's talk about those next Tuesday. Cause I have a hearing in.
One thing I wanted to raise and is there's a bunch of motions in limine that are filed. Does the court prefer if we're going to join in these other motions that other people filed? Individual joinders in each motion or an omnibus joinder?
You can do omnibus.
Okay.
See you next Tuesday.
Thank you.